Hi, in this presentation we will discuss about patent infringement, injunctive relief or injunction in case of patent infringement. Injunctive relief or injunction. Injunction against patent infringement is granted to stop further infringing activities by infringer. Under 35 US Code Section 283, courts may grant injunction according to principle of equity to prevent violation of any right secured by patent. So, courts may grant injunction for preventing infringement of patent rights. Injunctive relief is discretionary and not mandatory. Court will decide. It's on the court's discretion. Grant, denial, or modification of injunction is reviewable under abuse of discretion standard. Under 28 US Code Section 1498, no injunction can be issued against US government. However, if there is a patent infringement by US government, then patentee may claim for damages, but he will not get injunction. Patentee is not entitled to permanent injunction against use and repair subsequent to laches period for device made during laches period. Coming to types of injunctions or injunctive relief, there are two types of injunctions: preliminary injunction and permanent injunction. Preliminary injunction is granted during course of trial as immediate or initial relief to patentee. Preliminary injunction is temporary till final decision on permanent injunction is taken by court. If final decision is that permanent injunction is issued, then temporary injunction will become permanent injunction. If final decision is that permanent injunction is denied, then there is no injunction. Even temporary injunction will go. Temporary injunction is granted to stop infringement till final court order. Now coming to permanent injunction. Permanent injunction is granted as final court order to stop infringement permanently. Now coming to factors considered by court in granting injunction. First factor is likelihood of success in case, and this factor is for preliminary injunction. Court will see the likelihood of proving infringement, and court will also see the likelihood of withstanding invalidity challenge claim. Second factor is irreparable harm or irreversible harm. Harm is usually presumed by court in case of patent infringement, and this factor usually go in favor of patentee. Next factor is damages. If damages are inadequate, to compensate for infringement. The court will see if damages are inadequate or adequate, and court will analyze and will consider this factor in granting injunction. Next factor considered in granting injunction is balance of hardship. Hardship to patentee if injunction is denied, and court will also consider hardship to infringer if injunction is granted. So hardship to patentee may be if injunction is denied, he will not be able to enforce his patent rights. And hardship to infringer if injunction is granted, an infringer has to withdraw his product from the market. So he has lost all his investment in the product. So court will see hardship to both patentee and infringer and will balance this hardship factor while deciding the grant of injunction. Next factor considered by court in granting injunction is public interest in terms of impact on public health and public welfare. So this is public interest exception. Courts usually favor patent protection with limited public interest exception. So this factor also usually go in favor of patentee. Now coming to hardship of preliminary injunctive relief or preliminary injunction. Hardship for infringer if preliminary injunction is granted, then he has to withdraw his product from market, which can be devastating because he has lost all his investment in the product. Now he has to withdraw this product from the market because of injunction. Hardship to patentee if preliminary injunction is denied, even after showing strong likelihood of success on validity of infringement, then hardship to patentee will be a serious delay in exercising its limited time patent rights. Now coming to injunction contempt proceeding. If there is a contempt of injunction order, if infringer is still infringing the patent, then patentee may bring the contempt case in court and may start contempt proceeding in court. Contempt proceeding for violation of injunction order or injunction decree. If violation of injunction is found, then violator may be punished by fine payable to patentee and also infringement even in civil contempt. Contempt order is final and it is appealable when opportunity to purge contempt has passed and position of parties has been affected by contempt order. Patentee in contempt order may not seek to broaden scope of claim that were adjudicated and thereby catch modified device. Slide on summary judgment just for information. Patent litigation frequently is very complex, long, difficult, and very expensive. So the party, they may opt for summary judgment to narrow issue for trial. They may file for summary judgment. Under Rule 5C, summary judgment is proper if pleading, deposition, answers to interrogatories, and admission on file together with affidavit, so that there is no genuine issue as to any material fact to be tried in trial, and that moving party is entitled to summary judgment as a matter of law. Then in that case, court may issue summary judgment. So that's all in this presentation. Thank you very much.